What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Shepke, got anything to say?
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Friday. Happy Friday. We made it to another end of a work week. Hopefully you guys had a good week. Hopefully you guys have a great weekend planned. All right. I don't know why that was so hard to spit out. Words are hard. We already know that. All right. Let's see. Tonight, I've got two cases. I have got a sovereign citizen that many of you may have already seen. It's been on a few channels today. Fridays are slow. Fridays are slow court days. A lot of landlord-tenant cases. But there was a sovereign citizen today, which was a good one. I also have one from earlier in the week, which was it's a great one too. So we are going to start with I don't know which one. We're going to start with the one from earlier in the week with Judge Hesselink. We'll do the sovereign citizen last. It's a good one. It's a good one. That's all I got. I don't know what else to say. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your sharp kick back flips. Let's go. Wait, which one did I say I was starting with? Let's start with this one.
All right. Next case the court has is Jeff Hodges versus Andrew McHune. That's file 25-40756-GC. Set for a motion this afternoon. All right. If I could have the party.
I love that this was the first comment. Mr. Beef's always trying to troll me. I love it. No one in this here. I'll even show you the wreck that I am right now. That you can see that nobody has my haircut. Hold on. How do I turn my video on? See, I told you.
State their names for the record, please, starting with counsel.
Good afternoon, Your Honor. Matthew Kassar here on behalf of the defendant, Andrew McHune.
All right. And Mr. Hodges, you want to place your name on the record, please?
Hi, good afternoon, Your Honor. I'm Jeff Hodges.
I was personally invited to that chat. When I jump into those chats, I do watch, I do pay attention. I don't usually interact too much. So if you see me over there, it's not because I'm throwing my support behind them. It's because I was personally invited. That's why. I do watch, I do pay attention though. But yeah, I believe you when you said it turned into conspiracy theories. I believe that.
All right. I have a motion from counsel for summary disposition, and I have a dismissal document from Mr. Hodges asking me to dismiss the case, and then I was handed today a form that's been mostly almost blacked out, so it's unintelligible for Mr. Hodges. So I'm going to ask Mr. Hodges first, what is this document that you sent to the court or dropped off at the court today?
This shows the criminal matter has occurred by Mr. Andrew McHune and the legal counsel for attempts to interfere protected activities.
Mr. Hodges, this document doesn't show me anything. It's so blacked out. I don't know if you can, I know you can't read it from there, but it is without a doubt, there's about 6 words in total that I can read, none of which have any relevance to anything. I can read the words from, subject, date, to, FOIA, exempt, and then there's a federal court statute, 31 U.S.C. 323.
Dude sent Judge Hesselink a CIA blacked out file. Yeah, you can read only the words I want you to see, Judge, and that's what you have to make a decision on. That's how this works, right?
But it doesn't tell me what case, when, where, how, or why. So this document is
cannot tell
absolutely
you.
useless.
I cannot tell you the details because of the federal regulations and the confidentiality requirements. But because of this matter, I'm falling under the federal statute outlined in that particular paper, and any attempt to interfere that a protected activity is violating the criminal law. And the law is cited on the title, the confidential FOIA exempt, and the word after that.
The Freedom of Information Act has absolutely nothing to do with this case or a criminal case. There might be contempt or there might be some sanctions for violating a Freedom of Information Act request, but Freedom of Information Act is simply a discovery mechanism with absolutely no connection to this case that I can see at all.
It's because of the law, how it's designed. This whole matter is FOIA exempt, and attempt to interfere.
I don't understand what you just, sir, hang on a second. I don't have any idea what you just said. This whole case is under the FOIA? That makes no sense to me. Explain that.
Because of the activity I did under the word after FOIA exempt, the 31 USC 53, as you can see, the information, as you see now, has to be redacted because of the confidentiality requirements. And
are you claiming to be a whistleblower, sir?
You are correct.
How does that have anything to do with this case?
And the counsel has tried to use irrelevant material that is a part of the investigation against me, and either intentionally or unintentionally, that constitutes the witness intimidation.
Do you have a court order from the federal district court that says that we can't do anything in our case?
I don't know. This is way beyond a civil court.
Way beyond a civil court. Way beyond a civil court. Yet you sued him, and you sued him in a civil court. This guy's my favorite court genius. He really is. I want to see more of him. I really do. Unfortunately, I don't want to be the recipient of one of his lawsuits. That's a good way to say it. Phil, thank you so much for the super chat. I appreciate it. Colin, haircut fun. I do need a haircut. This is actually, usually I have product in my hair, but because I've been spending a lot of time working out, and I've been spending a lot of time with myself over the last week, that I haven't put any product in my hair. So this is just natural. Also, I'm kind of sunburnt right now. I decided to go to the pool yesterday. I didn't put sunscreen on. Dumb idea. Phil, thank you so much for the super chat. Legal Fiction as well. Protected Activities Month. Thank you, Legal Fiction. I appreciate it. And another squid with 5 gifted memberships. Thank you so much, another squid. Welcome to the 5 new members. Thank you to the 3 of you. You guys are awesome. Okay, let's go.
Says who?
Well, this is a federal criminal matter, and I don't know why someone thought it's a good idea to get involved in this whole matter and keep going after me. And I think the action by McHune and the CEO is very unwise.
Sir, I don't know that this is a federal criminal matter. You sent me a piece of paper that has on it the words FOIA exempt and a statute number. I don't have any idea that this even applies to you. I don't have this document shows me absolutely nothing. So there's nothing that this paper does or has or will have in this case. It's got nothing to do with this case as far as I can tell. I don't have an order from a court that says I can't do anything today.
The Exhibit A is violating the law cited in this paper.
I don't know what Exhibit A is.
That is your document presented by the legal counsel of your defendants. Also, the defendants' activity invoke the violation under the law cited.
All right, Mr. Kasser, do you want to respond to that?
Your Honor, I guess several things. I haven't seen the document that Mr. Hodges provided to the court today. And I'm nearly positive it makes no difference. There's no criminal matter here that I'm aware of, not involving my client, Mr. McHune. Last week, I believe Wednesday, maybe Thursday, Your Honor's clerk gave me a call and said Mr. Hodges wanted to voluntarily dismiss this case. I spoke to my client and we said we will consider that, but we would need to have the dismissal with prejudice so as to end this frivolous action. Mr. Hodges has not provided any contact information, so I wasn't able to contact him by today's hearing, so I figured we could potentially hash out the details of a dismissal today. Now, given these new, I'm not sure if they're allegations or into myself and my client, I'm not sure that my client is going to want to drop this motion, which seeks sanctions, seeks fee shifting for what we've had to do to dismiss the several cases that, by the way, Mr. Hodges has brought, Mr. McHune and previously Ms. Sheldon, who this court dismissed that case a couple weeks ago, did not bring any cases against Mr. Hodges, has not pursued any action against Mr. Hodges, terminated him for a reason, for valid performance-based reasons, and has since had to defend against frivolous actions filed by him. So that is all to say, we were open to exploring a voluntary dismissal from Mr. Hodges. I'm not sure if there's going to be additional retaliation and frivolous suits or criminal actions or anything like that. I'm not sure. I may have to talk to my client again about whether we want to continue to seek sanctions, because frankly, I don't even understand what the allegations are at this point. And I'm happy to argue the motion for summary disposition today too. But, I guess I'm not sure, Your Honor. I'm not sure where to go from here because I figured today would be, trying to hash out how the voluntary dismissal is going to go, not new allegations about criminal conduct on someone's behalf. I'm not sure whose. And FOIA, I don't think is relevant in any way, but I assume that the court is aware of that as well.
Yeah. All right. Mr. Hodges, your motion for dismissal is not granted. Right on the form that's used, and it's in the statute as well, it says under section 2C, no answer or motion has been served upon the plaintiff by the defendant as of the date of this notice. And that is absolutely wrong. Absolutely.
I don't know why I'm having so much fun with this case. MB, thank you so much for the super chat. Happy Friday to you as well. Thank you. I appreciate it.
It's again an example of you misusing the law. This was filed with the court July 14th. This request for dismissal, and we received from counsel the motion to dismiss at the end of June 26th. So I'm not granting your dismissal. Counsel, do you wish to argue your motion for dismissal, summary disposition?
Your Honor, if Mr. Hodges would like to discuss submitting collectively an order of dismissal with prejudice of this action, we are happy to do so. If that is not the case, because as you've mentioned, it needs to be by stipulated order at this point because there's a motion pending. If that's not the case, then yes, we're going to proceed with our motion for summary disposition. So not to kick the ball to Mr. Hodges, so to speak, but we need to understand whether he is going to agree to dismiss this case or not. And if not, we will proceed with arguing the motion and seeking sanctions.
All right, Mr. Hodges, do you wish to seek a conciliatory agreement to not prosecute? So the case will be dismissed without prejudice, or excuse me, with prejudice?
For this particular case, yes.
This is the only case that I'm aware of that is still pending.
Right.
Go ahead.
Let's use small words and say them quickly. He said yes. What do you want to do next?
Let's use small words and say them quickly. Jeff Hodges. I rest my case. Too soon?
Your Honor, I think because Mr. Hodges is reserving his right to file more frivolous actions, I think we need to go forward with the motion.
Fine with me. Please argue.
Okay. Your Honor, just briefly, I know you have the papers. This is a frivolous action filed by Mr. Hodges. It's initially filed as a small claims matter, and there was given a short paragraph, a couple paragraphs about how Mr. Hodges is seeking the expenses of his legal work to file this claim, which I think comes out to $60, $70. Because Mr. McHune, who is my client and who is the chief executive officer and president of Wade Trim Associates, Inc., has, quote, maliciously escalated a business dispute with Mr. Hodges. There is no evidence that that has happened. Mr. McHune has defended himself in this case by filing a motion for summary disposition, and that's all. And even if there were anything, even if there was any cause of action actually pled, which there's not, there's no damages. There's Michigan, like all states, operates under the American rule. Fees don't shift unless there's a statutory exception or some other exception in case law, which there's not. So there's no damages in this case. There's no cause of action in this case. And Mr. Hodges' statement actually says itself that it is retaliatory and threatening against Wade Trim and Mr. McHune. And I quote, and I think I need to quote to understand or to put on the record how kind of incredulous this claim is. Mr. Hodges has pled that, and I quote, Andrew McHune and or his company are insignificant and irrelevant to me, to waste my time and valuable resources, and I hope this is a clear discouragement to any further illegal and adversary actions under Andrew McHune against me. I hope Andrew McHune will not mistake this as an encouragement for further retaliation and or adversary actions. Your Honor, this case is being brought to threaten.
Let's this is why you don't go pro se, people. Especially when you're filing a lawsuit. Oh man. Yeah, I'm filing this lawsuit, but I just want him to know that I don't care about him. He doesn't bother me. I don't care about him. I hope he doesn't do this again. That you're gonna need a little bit more than that. Chris, I love the Foxtrot news. Thank you. Also, Chris, 5 gifted memberships. Thank you so much. I appreciate it. Welcome to the 5 new members. Good to see you, buddy.
To harass and has no merit whatsoever. And I do think that in this case, because of what is going on and because Mr. Hodges is now threatening more actions against either my client or Wade Trim or other employees of Wade Trim, I do think that sanctions are appropriate, despite the fact that we are well aware that sanctions are generally reserved for situations where people are represented by counsel, because there is some leniency. But as we cited in our briefs, that leniency is not, it's not absolute. And I think to disincentivize Mr. Hodges from further abusing the legal system, who he has now threatened myself too, with some sort of vague allegations of criminality, I think that sanctions in the form of fees for bringing this motion are warranted. And that's all, Your Honor.
Mr. Hodges, how do you wish to respond?
Well, after termination, in order to get me further into trouble, they have made a false police report accusing me with false allegations. And in this process, it has the attempt to interfere with the protected activities, that is a criminal matter at unrelated place. So because of this action by Wade Trim, also involving Andrew McHune himself, this constitutes criminal activity for everyone involved. And that's the reason I prefer to see this as de-escalation. And I have attempted requesting mediations again and again, trying not to escalate the situation further. And Wade Trim has deliberately refused our mediation attempts. causing escalation to this point, and I have to bring this out for my own defense. And they get into something they have no idea, and the consequences can be severe, and I hope it can be avoided.
Mr. Hodges, what police report are you referring to?
A police report was...
You've not filed any police reports with the court?
No, it's filed by McHune, and this was included partially in the material submitted by the Council of McHune, by Kent County Sheriff's Department.
Gertrude, thank you. Late fee, unfortunately, you've already seen this one. Yeah. Wait, hold on. Late fee, fortunately, I've already seen this one. Yeah, Skeptic played this one earlier this afternoon. I know someone else played this earlier in the week. I had to deal with Skeptic that I would wait till after he posted it to play it. So that's why I'm playing it tonight. Otherwise, I probably would have released it on Monday or Tuesday. So that's why I'm playing this a little late. But this is pure gold. I can't hold it from you guys, especially the ones who haven't seen it. But I do appreciate the super chat. Thank you so much.
Counsel, you aware of what he's talking about?
Yes, Your Honor. There was a police report filed after. So I guess let me back up, Your Honor. Attached as Exhibit 2 is the affidavit to our motion is the affidavit of Andrew McHune. Attached there too are, I think, 60-something pages of very concerning, violent, threatening social media posts from Jeff Hodges that McHune became aware of after his termination and felt the need to file a police report, which is, of course, its right to do. We're not sure where that has headed because obviously McHune isn't conducting the role of the police. We just reported what we felt needed to report and move forward. Some of the reason that was reported was because there was a series of, which are highlighted in our briefs, Your Honor, series of very threatening and violent statements that are made against employers and managers, and demonstrated a pattern from Mr. Hodges also, not only with the violent conduct, but his desire to use the legal system against his former employers. So that is the police report I believe he is referring to. That is not Wade Trim's determination of whether the police are going to continue to investigate, but it is relevant for purposes of this motion, which is seeking dismissal of these claims, which have zero merit, and Mr. Hodges has not made any argument as to why this case should not be dismissed, but also why there should be sanctions to halt these frivolous filings and to kind of cut it off now. As again, we were willing to look into a voluntary dismissal. We would need to agree to what the language was for the dismissal. But now apparently Mr. Hodges has further plans to file actions, and that needs to be stopped. And this court can do so by entering an appropriate sanction.
Thank you. Mr. Hodges, your claim when it was originally filed under the small claims matter before it was moved to the district court said that Mr. McHune maliciously escalated a business dispute under his instruction through some series of attempts to retaliate, harass, intimidate, or stalk you. Tell me how that occurred.
The general counsel, the description he has about the online post, many of them dated exactly around the same time frame as this paper, September 13, 2024. They are protected activity, and any attempt to use it against me is a criminal conduct. So please don't do that.
Mr. Hodges, what you're alleging is action taken by counsel after you filed your small claims matter. That you can't do something that happened after that to prove something that's supposed to be already in evidence. I'm asking for what evidence at the time that you filed your small claims case shows that Mr. McHune maliciously escalated a business dispute under his instruction.
by filing the police report, and
That's
there were
afterwards,
few
sir.
employees.
Sir, that's after you filed this matter. He responded in the way that he did. I'm asking you, what did he do before that you're complaining about originally?
This particular case was filed in May this year, and the police report was filed in late April this year.
So how is that in any way connected to the firing of you from Activent Incorporated when Mr. McHune works for is the owner of Wade Trim?
Because in my LinkedIn history, there were few employees seeing my profile, and that's the time they were using that information against me by filing a false police report in late April 2025.
So what is your proof that it's a false police report?
The false police report is included in your hands, and the local
What
prosecutor.
proves that it's false? What proves that it's false?
Because the accusation is untrue, and they are misused against me, and
Saying that
that's
it's
the protected
untrue and
activity.
it's false doesn't make it so. What's your proof that it's false or untrue?
The content is misused and irrelevant. Thus, it's an abusing the privilege to file a police report against me.
What is untrue about it? They just printed out what you wrote.
The action of the police report is frivolous. That's the point I have.
Say that again, because I didn't understand what you said.
It's the frivolous action by a Wade Trim to file a police report like that. And
what is the word that you
attempt?
No, the word that you're using before action? I don't understand what you're saying. It says I can't pronounce what you just said.
It's meritless for them to file a police meritless to file a police report, and it's a misuse of their position.
Why is that? Because you don't like it?
It's because it's an attempt of interference of their protected activity.
So you file an action against the boss of Wade Trim because you got fired from the company that is a temp service for you to work at Wade Trim, and now you're mad at them for getting out your posts on the public access social media. And again, I still see absolutely no connection between those things. Why is it wrong for them to find out what you posted?
Because those posting was a part of the larger protected activity to go after other companies.
Protected activity for what?
The whistleblower activity itself.
You're not whistleblowing. You're spouting off some political rhetoric.
Yes, which is
that's not whistleblowing. And there's what case were you involved in at that time that you were whistleblowing on? Who did you whistleblow to? What protection did you receive from that agency?
You can probably subpoena that person, Neil, and I can provide the full name.
I'm not subpoenaing anybody. I'm not an investigator. This is a court. Where's your proof of any of those things? You come in here telling me that you're a whistleblower. I've got absolutely no proof of it. I see some social media posts of a man who's upset and is telling people how to do certain things if they don't want to get fired. You get fired, and now you're mad at them posting, having access to the very things that you posted about. What has that got to do with anything in this case?
That's when I was trying to talk to some of the employees of certain companies to get them to talk. So I can verify the information from within with the public information to verify the misconduct of certain organizations doing certain business, violating certain federal laws. And I submit such information to the particular federal agent that was cited, redacted in that particular email. creating the TCR. And I have redacted the full number of the TCR, but you can see the first 2 digits out of that, which is 14. There are around half a dozen TCRs being associated, and they are still actively working with me to continue the investigation to hold those companies accountable.
Mr. Hodges, you strike me as a conspiracy theorist of the worst type. You went into this, it appears to me, from reading all of your statements in here, you went into this whole deal trying to figure out a way to sue this company. And you're not even suing the company that hired you. You're suing a different company that was engaged, had a place of business, and you got sent there by the company that hired you. You got fired for being a bad employee, and now you're whining about it because your social media posts caught up with you. This is the definition of a frivolous lawsuit. The quote made by counsel is very telling. Even in your initial pleadings, you were telling them that you're retaliating and that you're doing things to set them up for harassment things. This is the worst misuse of the court system that I've seen in a long time. Your dismissal paperwork shows me that you're not filing things in good faith. I was the judge in your previous case against one of the other employees of Wade Trim. I dismissed that matter, and quite frankly, I was surprised that they didn't ask for costs and sanctions in that matter. So counsel, I'm granting your motion for summary disposition, and I'm granting your request for costs. Did you submit a proposed judgment to me or not?
No, Your Honor, we will do so, and we will also submit a breakdown of the costs and fees for Your Honor's consideration.
Thank you very much. That's all for today then.
Thanks, Your Honor.
Preferred Credit Union versus Franthia Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter,
Was I muted the entire time? You guys didn't hear a word I just said, did you? Definitely muted. No. I just thanked Mayor for his super chat. I said a lot of really cool things. Like I said so many cool things that I mean, I might have solved, world hunger. You have no idea. Oh man. The mute button. I thanked Mayor for his super chat. So thank you, Mayor, for your super chat. And I said, Jeff Hodges, I really hope he files another lawsuit against somebody. Please don't make it me. I would love to see that guy in court. Something along those lines. I had a lot of fun watching that case. That was about it. Now we're moving on to the sovereign citizen. Yeah, that was about it. Yeah. Okay. Sorry for the mute button. Let's go.
Is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the family, Franthia family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or implied legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthea.
All right. Last name Price, Price.
I am.
Very good. And Mr. Bakukio, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court. Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Bakukio, this is not your motion. This is Ms. Price's motion.
It is, Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. I'm prepared to assert preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which collectively...
Let me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So,
Okay.
Your Honor, may I respond?
Yeah, go ahead, Mr. Bakukio.
Couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case. So any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthea Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per. But
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
Okay, whatever that means, Your Honor. This is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Let me just pause you for a minute, Mr. Bakuko. Something I did see that I did recognize as I paged through the file was the affidavit of transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred, and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah,
Okay.
if I may speak.
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record, that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of a contract as well.
All right. Well, here's my where I sit on this one, Ms. Price, is that my position legally here is I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me, it's not a full record, it's just a transcript of the summary judgment hearing at the in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery. Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or, things of that nature. And I can tell you from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again, and the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion, and I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Ms. Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Ms. Price, like I say, there is documentation and it is strictly required by the appellate rules. There's no way, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, a person
The final countdown. That's one of those song ninjas. Yeah, the term song ninja. So many good memories. Yeah, when the final countdown is a song ninja term. If you say to somebody that knows the song Final Countdown, they'll instantly sing the song. So it's a song ninja. There are a few words in the English dictionary that if you just say them in the right order, someone will instantly start singing the song. So that's what a song ninja is. So yeah, Final Countdown. The final countdown. I'm still here. Let's catch up on super chats. MB, mute skills on point. Yeah, no, they're not. Yeah, they were so much on point that I'm like, I can't even talk anymore. Like, I'm just gonna let the video run for a little bit. But MB, thank you. Cheshire Cat, the mute button remains undefeated. It does. I can't beat it. I cannot beat it. Thank you for your super chat. And we have a new member, Straw Carpenter. Thank you so much. I appreciate it. Welcome to the family. I just had to look to make sure I wasn't muted. Just like watch me be muted right now. All right, you guys are awesome. I appreciate every one of you. Let's finish this one up.
Appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. That's, I think, all we can do for today.
Oh, Chris. First off, thank you for the super chat. Second off, I can sing. I can actually sing. I just don't really care to. 12 years of choir. I can actually sing, I promise. For me to actually sound good, though, I actually have to warm up, do the exercises. I got to put a lot of work into actually singing okay. When the naturals can just belt off anything at any moment and just sound amazing. So, but thank you, Chris. I appreciate it.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor, or is
No,
Your
I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little, I'm
Yeah,
a
no,
little
I do have
remiss
a bunch of
about it.
stuff that you filed that
I love you guys. I love you guys. Legal Fiction, that was perfect. I'm not gonna sing that. That is a sacred song that I cannot butcher. I refuse to butcher the song. I only sing that to when I'm in private. But everybody knows the song, and no. Queen is sacred. Nope. Won't do it. Won't do that one in public. But Legal Fiction, thank you so much.
appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here was the no.
I said Queen. The second I said it, no. The second I said it, I'm like, no. And then this, no. I know it's Journey, guys. I know it's Journey. I've had a rough week. Oh, the second I said it though and hit the play button, I'm like, no, I just messed up royally and I'm live. I can't go redact that. You know what? Let's just go. That just shows you my song knowledge. You guys can make fun of me. I'll take it. I will take it. Let the insults go. I know that was Journey. Fuck.
Notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. And that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yep, and I did get the transcript, the one, but that's just the transcript of the the hearing on appeal, and that is part of what I need. Well, and I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, it usually.
Girl named Joe, thank you so much for the gifted membership. I appreciate it. Welcome to the new member. Girl named Joe, thank you. Sparkle Poots, we love you. One job. You have one job. Sparkle Poots. Yeah, I do have one job, and it's to find good court clips to share. And I will be honest with you. I am absolutely terrible at matching artists with songs. It has been an issue I've had my entire life where I've actually created like little sayings in my head to help me. And what the one on that song that just failed me was, there was one time I stopped believing Journey is going to be so pissed. That's the way I remember things. And that failed me there because I didn't think, I just spoke and I did not think about it. Journey, forgive me. I apologize. Sparkle Poots, thank you so much.
Usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to, put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision-making. And, since I'm requesting that brief now, I just thought I was needing the claim of appeal, but since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days, can file whatever he wants in response to your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm going to do this right this time, this coming next time. There's 60 days you need to brief on appeal explaining the errors of the lower court.
Correct. And the record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor, but if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need is that record from the lower court. Mr. McHune, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to.
Chris, thank you so much for the super chat. A girl named Joe married the man from Uncle. Would they have an Uncle Joe? Think about it. I don't want. Okay, all right. I see what you did there, Chris. I see what you did there. Thank you for the super chat.
Any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
Copy obviously went to Ms. Price, so she should have received
yes,
all those filings as well. And yeah, normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Ms. Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi's asking me for it, and it's got to be certified because it's on appeal. They at least have done that before down there at the Kentwood Clerk's office, so it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then, do I use the same case number as well?
No, it'll be assigned, and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number. That's the one I'm speaking of.
Yep, that is the appellate case number.
Okay.
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different number.
record, then you got to
Yes.
go with that number down there.
Okay, thank you. I appreciate your help, sir.
Very good. Good luck to you, ma'am.
Thank you.
Thank you, Your Honor. Thank you, Ms. Price.
All right. That's it. That's all I got. That is all I have. Thank you guys so much for hanging out with me tonight. I appreciate it. And I do apologize again. I'm so sorry, Journey. I am so sorry. It's amazing that one word can mess up an entire string. I have felt so guilty about saying that. I didn't. Yeah. No words. No words. Anyways, you guys are awesome. Thank you so much for hanging out with me tonight. The super chats, gifted memberships, membership milestones. Thank you so much. Mods, you guys are awesome. I don't thank you enough. I should thank you every single night, and I don't. And I apologize for that. Mods, you are the backbone of the channel. Thank you so much. Everyone else, have a great weekend. Tomorrow's Saturday. I am off. I'm still taking my Saturdays off, guys. I'm still gonna take my Saturdays off. And I think that's important. So I'm gonna hang out tomorrow and work on myself. So no stream tomorrow. I'll be back on Sunday. Have a great night. I am set up to raid Lone Wolf, the final countdown. The final countdown. See, yeah, don't do that. Don't do that to me. Stop Song Ninja and me. All right. You guys have a great night. Have a great weekend. Don't do anything dumb. You do not want to end up on my channel, especially if you live in Michigan, because I will find you. I will. Go tell Lone Wolf I said hello. I will see you guys Sunday. Until next time, bye.